Ladies and gentlemen, as you can all notice, we have a very prolific start to the program here in the presence of our legal luminaries. But it's also time to set the tone for the program on what's in store and what is the theme of the entire program, for which I'd like to now invite on stage Akriti Raizada, who's the founder and CEO, Legal Era magazine with ATLS Legal Media Group, to please come on the stage.
Good morning, friends, and a hearty welcome to the Legal Era Insolvency Summit 2019. We are privileged to have Honorable Justice Arjun Sikri Sir, Honorable Padma Shri T.K. Vishwanathan Sir, Honorable Shri Ravish Kadam Sir, and Honorable Shardul Shroff Sir to join this conference today with us. I would like to thank my distinguished panel on the dais for giving us their valuable time and presence for the conference today. London, Hong Kong, and Singapore, who have flown to participate in today's gathering, and our speakers from India, who have taken their valuable time to be part of this conference. We also welcome all the participants from various parts of the country, and we welcome the member of the press as well. All of you have become an integral part of Legal Era. Legal Era has become a unique institution of its own kind, a unique integrated organization, and it often defines as the power of one voice because of our people that are with us and behind us, our eminent lawyers, senior counsels, leading corporate counsels, judges. So we are a full network of the legal fraternity and leading experts. Legal Era today is one voice, a collective think tank of like-minded experts. We learn, engage, develop, and grow together. Each one of you have a knowledge bank of unique experiences that turns to be helpful learning, and when we meet each time, we have great takeaways from each other. Today, we have assembled for the 4th edition of Insolvency Summit. From its inception, the Insolvency and Bankruptcy Code 2016 has been hailed as a fascinating piece of legislation and a chosen course of timely resolution of corporate bankruptcy, wherein creditor can recover their dues partly while the company in questions get a fresh lease of life. In reality, however, the code has been facing multiple challenges and including practical difficulties in interpretation and conflicting judicial pronouncement, which have slowed down the pace of bad debt recovery. The code recognizes different categories of creditors based on security held interest, gives priority to financial vis-a-vis operational creditor and secured vis-a-vis non-secured creditors. However, the judicial pronouncements of the National Company Law Appellate Tribunal and the judiciary in this has been conflicting. Today, our experts shall throw light on such conflicts and challenges faced by IBC. Our distinguished guest on the dais will speak on the recent IBC amendment and what should be the future trends. Moving on, our speakers during the day shall take forward the discussions on the process of liquidation in going concern companies, what should be the financial and effective restructuring model? What are the challenges faced in arriving a resolution plan? What is the role of intermediaries in the insolvency process? Common law perspective on cross-border insolvency, the role of judiciary in regulating cross-border insolvency and dispute resolution and litigation funding. Experts will also include in their discussion the classification and prioritization of creditors under the code. It is important to appreciate that the code is essentially a work in progress whose jurisprudence will continue to evolve in the foreseeable future so as to match the complex demand of the Indian economy. And the teething trouble will be ironed out as the country's distress pace matures in the coming month. With that, I welcome you all to the 4th Annual Insolvency Summit. I hope we have great takeaways, and I hope we learn and exchange knowledge to make our tomorrow better. Now, I would like to invite our chairperson for the conference, Padma Shri T.K. Vishwanathan Sir, for his opening address. Please join me in welcoming Padma Shri T.K. Vishwanathan, sir. Thank you.
Faculty. Since this is the first occasion I am sharing the dais with Justice Sikri after his appointment as the international judge of the Singapore International Commercial Court, I take this as a great honor and privilege. It's a matter of great pride for Indian legal scholars that his knowledge and expertise has been recognized internationally, and more judges are likely to follow this. He has been a great role model for all the youngsters who are all assembled here, and it sends a very strong message to the global community. Judges are second to no one. They can stand up to any, measure up to any standards. Thank you, sir. We take this great thing and we are really proud of you. When I heard this news, and this is the first time I can see all of you, give him a big hand. Great honor for the Indian legal fraternity. It's really something which is we should be very proud of. Thank you. Having said that, let me start with the topic today. These recent amendments and future trends. I just want to recapitulate the situation which was prevailing in 2014 when Mr. Arun Jaitley, whom I miss him very badly, all of us miss him. It's a great tragic loss to the nation that we lost him. He is the one man who could see the future. And I was very fortunate to have earned his respect when he told me in 2014 August, you have tried many legislations, you try your luck with this one. He was not probably sure of whether this bankruptcy reform will take effect or not, because earlier attempts have failed and there was so much of uncertainty about the whole credit market. But we tried and things started with such a great force. I thought even God was supporting us. All of you know the pace with which the legislation moved. On November 4th, 2015, I handed over the bill, the code, Insolvency and Bankruptcy Code, cut and dried with everything, with the statement of objects and reason, with the Hindi copy, ready for introduction. The bill was introduced in December 18, 2015, passed in 2016 March, went before after the committee going through it. Then by October, the bankruptcy board was in position and we started the process. So this really shows how the law reform, if the government wanted, can take effect. The IBC code, in fact, represents a new generation of law reform because I have handled I've been in the law commission for quite some time. We handled many legislations and I've seen the passage of many legislations, because many of the cases, after the draft leaves the draftsman's hand, there is no control over the draft because it goes before the committee, gets changed there, the parliament amends it, and it emerges in a very different form. But this legislation, this code, had continuously stuck with me. It's still with us. Me and Sharul are working on it continuously on a day-to-day basis. So this is something which is unique, which has happened, never happened in the Indian legal context. And I am only reminded of the challenge which Lord Macaulay would have faced when he had to draft the first penal code for India. He drafted it as a chairman, as a first member of the Law Commission in 1830. 37 he drafted and gave the code, but it was not enacted till 1860. It took some long time. I will just read out for your information, which you may not have access in any of the books. It's equivalent of the statement of objects and reasons which we have today in our bills. It is something, I'll read it out. In attempting to place the whole law of a country in a written form before those who are to administer and those who are to obey it, such a mutual relation will be found to exist between several parts of the law that no single and separate part can be put into a writing in a perfect form while the other part remains imperfect. That portion which is first selected to be first formed into a code with whatever clearness and precision it might be expressed and arranged must necessarily partake to a considerable extent of uncertainty and obscurity in which other portions are left out. Many questions still undoubtedly arise, occasioned by the uncertainty of other parts of the law to perplex the criminal tribunals, but it will be found that the definitions and other provisions of the code are framed to obviate as such as may be defined to remove such difficulties. Now he was aware when he gave this quote that India did not have a comprehensive statute law, and then I had the same problem when I was asked to assemble, to go through the entire statute book and come up with a comprehensive law. And then this quote came up, but like any other law, no law can be perfect because law deals with human behavior, and especially law which deals with market forces is very tricky. And you're all seeing that, and Shuttle will bear with me when we discuss in the committees. Daily something is happening and we are not able to know how to respond to these situations. This is a challenge which the company law tribunals and appellate tribunals have to deal with and come up with some solutions, because it's not possible for us to keep on amending the law on a daily basis. Let me get back to the amendments and what occasioned them. When we drafted the code, we were very much concerned with the prevailing state of the credit market. You know, all of them, the credit market was, the bond recovery was very poor. There was much emphasis upon secured credit, and the whole credit market was dominated with banks and financial institutions. So we wanted to move away from bank-centered finance, move away from secured credit, and to create a situation where people can come and start a business, and if the market failures or a normal thing, they should wind up and go away. Should not be a stigma. So with this mind we started working. So one of the fundamental principles which we worked was control of an enterprise is not a divine privilege. People should be able to let go if they think they cannot succeed, and they should allow others to take over and run the enterprise. When the court started operating, all of us knew what happened. As expected, there used to be a lot of disputes, a lot of challenges. We expected it. So the first challenge was met by bringing in 29A. Now this 29A, the factors, the contents of 29A was very much within the domain of the Committee of Creditors. We deliberated at length in the committee, in the Bankruptcy Reforms Committee, that whatever 29A has said must weigh with the Committee of Creditors even without express provision of the law. We refrained from putting too many things in the law because we didn't want everything to be a matter of dispute which will be dragged along to the courts. We never wanted this. We empowered the Committee of Creditors with sovereign powers, because you sit inside, cram and come up with a solution, because they know the market better than others. And we will stand by that. It's a market-based decision, not a judicial decision. So we did not have a clause to the 29A when we drafted the code. But then things happened, 29A came in. That is the first challenge when the government responded swiftly with an ordinance. Then, it had its own side effects, litigation, counter-litigation and so on. The second aspect, we never devised this bankruptcy code as a recovery mechanism. But then, things have started moving in that direction. Then we brought in this 12A, providing for withdrawal of petition applications, etc. The second amendment was meant to deal with the home buyers. So that was a very social problem which we had to counter. There was a lot of debate whether they're really financial creditors or whether they can be termed as financial creditors. But then there's a social problem government had to address. You can't sit back and watch. Then it also introduced an exception for medium, micro, small and medium enterprises. The code exempted them because then they are in a different category. You may right now see in America, they have enacted the Small Business Enterprises Reorganization Act. It's a very recent act, which puts subparagraph 5 in Chapter 11, which dispenses with many of the onerous conditions under the bankruptcy code. It doesn't have a committee of creditors. There is a trustee, an administrative trustee who takes charge of the company. The company is still the debtor. Then he gets a repayment schedule of 3 to 5 years to repay the debts. So it is something which has been welcomed in the United States, and when we draft rules under 240A to provide for medium and small enterprises, you may have to take something like that to deal with these things. Then the third amendment dealt with this extension of days, because this time limit which you prescribed was criticized very heavily by everybody. Saying, how are you prescribing timelines, or courts cannot follow, it has never been thing, etc. But then we have to have a timeline which has worked well. Now, all said and done, when we drafted the code, I could not provide for the cross-border provisions for the simple reason we didn't have the ecosystem, we didn't have information utilities, the resolution professionals who are the soul of the whole code, they were non-existent. But now the profession has emerged and it's shaping up very well. So time has come to have cross-border provisions, and we have recommended the unisectoral model law. In this process of whole drafting, I received a lot of inspiration and help from Justice Sikri and Justice Kaul, and Justice Badwa and Justice Jagannatha Rao. They are the people who gave me a lot of ideas how to go about it, and it's been a wonderful experience for me at this age, at the last stage of my career, to have given this code to the country, and it is taking up very well, and it's bound to have a great developments in the future. We are also exploring how to deal with non-banking financial companies, the bankruptcy of those things. We are handling that in a series of meetings. Shardul will talk more about it. By and large, no one should be a judge of his own cause. I should not sing praises about my code, but this code represents a new generation of law reform which has shown to the world. Law reform in our country had always been based on doctrinal research. I've been in law commission for a long time. We didn't have the funds to conduct meetings and seminars. We didn't have the wherewithals of collecting data, empirical research. There's no way of finding out the impact analysis. There is a talk about repealing old laws. Well, that is the duty of the legislative department. Once in 10 years, they have to do that when they are in charge of the statute book. What is more important than repealing old laws, which have dead anyway, they have no use, is more important is to study the impact of existing laws. Ministries are being allotted, each ministry is entitled to administer many acts under the allocation of business rules. They forget after the enactment of the code, they just simply forget and wait for the litigation to follow or a crisis to come when they try to undertake an examination of how the law is functioning. There is no systematic review of the statutes under the ministries. That is where impact analysis and empirical data is required. Brandeis brief is what the need of the hour to justify the validity of legislation, and the IBC code is simply based on data and market behavior. I thank Akriti and the legal era for giving me this opportunity to share the podium, some of my thoughts. I am greatly honored and humbled. Thank you.
Thank you very much, sir. In fact, we are truly honored to have your presence with us here, and thank you very much for sharing your dynamic thoughts. Ladies and gentlemen, on that note, let's move forward and now invite Shri Shardul Ashroff, who is the Executive Chairman, Shardul Amarchand Mangaldas & Co., to also share his insights and his views with this gathering. So let's have a huge round of applause, and please help me welcome Mr. Shardul Ashroff.
Mr. Justice Sikri, Mr. Vishwanathan, and my friend Ravi Kadam, and all of you who are present today. It is indeed an honor to come to this forum and speak about how the law has developed, in a sense that one reviews what has been the annual changes or major litigation or major judgments which is driving the change in the law. Having attended several of the international conferences where the code is debated and the opportunity for investment in distressed assets is discussed, I think the feedback that has come through is that we have achieved in a period of 3 to 4 years what other countries, including countries like USA, developed over decades, and the speed with which the reforms have happened, the speed with which judgments have come through, and the process has been quite remarkable. And we are now just into the phase where there will be judicial reforms or judicial treatment of how cases should be handled, or the legislative response in relation to what is still failing in the system. I think if one looks at this last amendment of 2019, clearly it is occasioned by the NCLAT judgment in the SR matter, which the tribunal evolved a completely new formation which is quite contrary to the traditional banking laws and the process of how banks have been creating priorities or being treated as secured creditors. And their charges are being registered under Chapter 7 of the Companies Act. And the honorable members of the tribunal of the NCLAT got on to a particular gap in the CIRP proceedings, that's the corporate restructuring proceedings, and held on to the principle that there is no constraint among them when they're dealing with a scheme of rehabilitation or a resolution plan, that they cannot change the order or they cannot alter the contracts of the secured creditors and treat both the secured creditors and financial creditors equally. Now, this has a far-reaching consequence in the sense that traditional banking, pricing of loans, the whole security regime, the whole unsecured creditor regime, the operational creditors regime would be shaken up quite substantially if this law was not reversed. And therefore, for the first time in 70 years, in 13 days from the date of the judgment, a change was introduced through an ordinance and then converted, of course, into a proper bill and an act. This is the fastest that any legislature or any central legislature has ever acted, and I don't recollect any such instance other than this particular amendment. And it was occasioned because all bankers across the world, and our largest banker, the State Bank of India, were quite outspoken and did mention that you cannot and should not interfere with the Committee of Creditors' decisions, especially because that freedom is made available legislatively. As Mr. Vishwanathan mentioned, it is almost a sovereign power which has been entrusted to the Committee of Creditors to decide how the distribution will take place. So it's a very unusual case where the resolution plan and the resolution applicant were accepted, and yet the tribunal chose to decide that despite the scheme having been approved and despite the resolution applicant having succeeded, it has the power to modify the distribution among the creditors, that is the financial creditors, unsecured financial creditors, and the operational creditors. This was unprecedented before that, and to equate financial creditors with operational creditors was for the first time evolved in this judgment. So the crux of this amendment, there are 7 or 8 amendments, but the main theme around the 2019 amendment has been the modification of section 30, subsection 2, clause B, because this is where the legislature has brought in the principle that the transfer of property principles of how distribution takes place among secured creditors vis-a-vis unsecured creditors, as also the provisions of section 53 of the code would apply even during the period of resolution and not merely in bankruptcy. Because the principles in bankruptcy were always clear that it would go by a priority, namely the resolution cost first, the workman's portion along with the secured creditors next, and then in a declining order, the equity players being the last. So this disturbance effectively by a judge made law was the raison d'etre for the modification of the code in 2019. There are some other changes which were also made and which will have an impact of the practice of insolvency, for the reason that one of the most sort of not emphasized amendment is the introduction in the concept of a resolution plan, the ability to conduct a merger or an amalgamation or a demerger. And this is significant for the reason that the previous judicial view was always that it is only the corporate debtor which can be dealt with in the code rather, and to introduce either a healthy company or transferor being brought in and two companies being dealt with under the code was not actually permitted. The previous judicial view was to bring in a new company which is not under stress and to use that as part of the remedial action in the code was something which was not contemplated, and actually it was being kept off. But realizing that the complexities of trade are such that it is necessary to have not just the purchase route or not just the asset sale route, which is the traditional remedy that the court applied for more than 2 years. This new area has been introduced, and it will introduce vast changes in terms of how evaluations of corporate debtors and the purchaser effectively, or the amalgamated company, would have to be evaluated. So this is a major practice change, and it will have a tremendous impact, because in a single scheme you could contemplate both the reduction of debt and the introduction of a new party. Currently the processes which have been adopted is cancellation of the equity of the old promoter and introduction of fresh equity in lieu and stead of the lost capital. So I think that's it's not been evaluated by the community yet, and it will come, because I think even the regulator has not been able to assess how to evaluate such procedures, because they're all based on marking systems which do not really extend to a merger, amalgamation or demerger. The other issue which is of a significant change was the complaints that which were being received by the IBBI in relation to the time taken for admission. There is statistics and empirical evidence to show that cases were dragging on for 6 months just to be admitted. Filings used to happen, but they would never come up for decision, and it would really almost take the whole time as is available for the resolution. 180 days or more have been seen in the system, and therefore the government felt it was necessary to put in a provision which says that you will justify why it has taken more than X days to admit the process. And this was an amendment introduced in section 7(4). The other amendment which was introduced, and I think it's more or less, I'm not sure how the judiciary will react to it, because they have developed a regime of their own, in the sense that the time taken for legal proceedings in resolution or in resolving the distress was, even prior to this amendment, 270 days. But those 270 days used to stretch to 400, 500 days, and there are cases which are now almost 1,000 days old, including the one which is being heard by the Supreme Court in SR Steel. So they actually reversed the judicial principle which was evolved and said that we are giving 270 days, which was the original statute, and 60 more days. That's it. And if you don't finish in that time frame, the company will go in liquidation. It's almost like a statutory period, that if you don't come about with a remedy at the end of 330 days, let it go into insolvency. I don't know how this will pan out with the judiciary, because judiciary being judiciary, they will justify a longer time frame, because this is not a clinical, day-to-day accounting for the judges. They have a huge workload, and to experiment with a fixed time dissolution concept is pretty rare. So I don't know how the final thing will pan out. The other changes are in the context of debenture holders and home buyers, which are very large constituents in the creditors category. And there is even now an extremely difficult approach as to how you resolve issues which involve 30,000 or 40,000 or 50,000 people in relation to a distressed home or distressed construction project. And they have brought in the concept of an authorized representative. But how the authorized representative votes, is he to vote on the individual decisions of the class? Is he to vote on the collective vote by majority in the class and represent that as a single vote was an issue which was contemplated when they amended Section 25A under the 2019 code, but it's still not worked itself out fully, and this is something which is again a work in progress. The last two issues effectively concern the binding nature of the order of the tribunal or the NCLAT, wherever the case is finally being decided. And they have categorically stated that the central government, the state government, and local authorities are bound by the decision of the tribunal. So to raise a dispute after the resolution or to rake up an unpaid government claim, whether it's of the authority or whether it's of the central government or the state government, is something which was clearly frowned upon. And this assumes a great importance now because of the PMLA Act and what is happening in the Bhushan Steel matter, where the authorities, the ED has staked a claim and put a attachment order on the assets which have already been sold and bought by the JSW group. There are now about 7 judgments on this issue as to whether PMLA has a priority over the IBC. And even the appellate tribunal of the PMLA authority has decided that no, the IBC has priority, except for one judgment out of the 7. 6 of these judgments have now held that the Enforcement Directorate cannot attach assets which have been sold or undertakings which have been sold in the context of a resolution plan. So this was one of the reasons which was emphasized and made into law. Then of course the miscellaneous provision in the context of the rule-making power was the scope of this particular amendment. But this is not really the end of the process of continuing change in the IBC. There has been a standing committee which was created by the Government of India, and I am privileged to be one of the members of that committee, where lots of other issues have been debated for almost 2 to 3 months now, and major changes have been effectively cleared through the committee. The cross-border insolvency group was one of the first changes which was gone through as part of the extended form of Section 234 of the IBC. It resorts to the model code of cross-border insolvency, but it leaves open Section 234 by which a bilateral treaty can still play out on insolvency issues, supposing one is not a member of the countries which have signed up to the treaty, then an alternate mechanism could continue in the law. And we've recently seen this in the Jet Airways case, where the Dutch authorities and the Indian authorities collaborated on how to resolve the cross-border insolvency issues of Jet Airways, because it's having locations outside of India also. And I'm sure in the session which comes up for cross-border insolvency, there will be much to discuss, because the power over the assets, if the registered office is here, what should be the principle? If the major assets are outside India, what should be the principle? It's a complete regime in itself as to how it should be done. Plus what happens in terms of authorities which are outside, who would really argue those cases? Can an international RP work in the context of an Indian resolution And if so, what are the extents of the powers that will be recognized in the conduct of cross-border insolvency? So it's a major thesis in itself. The second more important one, which has been taken up and actually signed off, is the group insolvency concept, and which is an enormously difficult task, though there are now 2 cases even without the change in the law in India. I happen to have written an article saying that this is, in a sense, again, the judge is creating the law, and there needs to be an appropriate codification of this, because otherwise this will lead to tremendously contrary judgments or processes, which is not healthy. In the cross-border insolvency, the triggers were the ILFS case, the triggers were the Videocon case and the Amtech Auto cases. So there are lots of cases where there are multitude of companies under a single parent. And that has problems in the law in the sense that in defining a body corporate, a non-bank finance company is excluded. And in most of the groups, there is always a apex corporation, which is known as the CICs under the non-bank financing regulations, where a single enterprise holds shares of the underlying subsidiaries, and the subsidiaries are primarily working and engaging themselves in the business. The topco effectively is just a mere shareholder of the shares which are downstream in the operating companies. Now, in the ILFS issue, what was noticed was that such companies cannot be brought into the IBC. And therefore, a different process was evolved under the Companies Act, by which the change of board was effected. There is no resolution professional in the ILFS cases, and there are more than 330 subsidiaries in that case. So it's an enormous task, which is already a year, an anniversary in that process has gone by. It is reported that about 50,000 crores out of 90,000 crores is likely to be recovered. So there could be a loss of almost 40,000 crores, which is significant. It's 3 times the value of what was lost in the Nirav Modi case. So you can imagine the kind of money which has been lost in that process. This is true of most of the group companies because of the exemptions which are there in the Companies Act in the space of infrastructure, that the limits of the capital which can be employed downstream doesn't exist in the context of infrastructure companies. That is one of the reasons why you see such a large problem in the ILFS cases. It may not be such a large hole in other cases like Amtech Auto or Videocon, except of course in an oil and gas kind of company, the same levels of investment are large and losses could be equally large. So that's how the future is being seen in terms of the macro picture. There are of course a lot of changes other than these 2 changes which are also being deliberated. Issues in relation to how you could, by notification under the code, bring in financial service providers as part of the regime of the IBC, because you need quick resolution. They will of course not deal with the systemically important companies which are in the non-bank finance space. And simultaneously, in fact, even today's papers mentions that the previous act, which was to regulate banks and systemically important NBFCs, is being revived and may simultaneously be brought in the November-December session of Parliament, which will look after a different method for reviving banks and reviving large NBFCs which have suffered tremendously in the last 5 to 6 months. One more change, which is an interesting change recently discussed, pertains to whether the resolution professional should include the previous official liquidator when the company is facing bankruptcy. And the rationale which has been provided is that there are large conflicts of interest in dealing with large insolvencies, and the government may need at times a more controlled resolution professional, being an officer of the Ministry of Corporate Affairs. I don't know how that will play out, because efficiency is a very critical factor, and knowledge is also typically a critical factor for a fast-track resolution. The issue of sale of a liquidated company or ordered to be liquidated as a going concern is another vexed question, because the very premise of liquidation or an order for liquidation is that all contracts come to an end. Directors get suspended or contracts of directorship come to an end. The workmen's contracts come to an end. The permissions, licenses, approvals come to an end. And then to say that in a liquidation, you can sell as a going concern, which essentially means that the company has not died. It is just in suspended animation, which is not what the insolvency law anywhere in the world says. But it's an experiment which is being tried by our government, saying that, look, if in the Indian circumstances it's difficult, you don't have so many job opportunities. The object of the act was to revive enterprises, not to really render them insolvent. So this is an interesting experiment which is being conducted for part of the future. One other suggestion would relate to upsizing the threshold level from the sum of rupees 1 lakh, which is the admission threshold today, to a much higher threshold, so that the volume of matters which lands up in the tribunal is brought down, and the more serious matters pertaining to insolvency are tackled, and time is not oppressive against the tribunal, because if they're to deal with miscellaneous matters and small claims, it doesn't really serve a purpose. So these are some of the changes which are on the anvil. I don't think the last word on what types of changes are still going to be thought through, but there is continuous dialogue among the members of the Insolvency Law Committee, where Mr. Viswanathan is also a member, and almost every 15 days we are having meetings to look at the various questions that have been brought up. There are other ticklish questions which are also on the anvil, but I wouldn't speak about them because there is a case going on which deals with that very subject which the committee thought about. So thank you so much.
Thank you very much, sir, for those insightful words on a very, very pertinent trends that we're looking forward to. On that note, we now march ahead for another keynote address by Mr. Ravi Kadam, who's the Senior Counsel with the Bombay High Court. So, ladies and gentlemen, please help me welcome on the podium Mr. Ravi Kadam.
Good morning. At the beginning, let me again also congratulate Justice Sikri for his particular appointment. On behalf of all of us, we are very proud of our judiciary, where we are now able to, from the last, of course, always had been, but now more and more recognized as a world-class judiciary, and he is definitely a symbol of our modern judiciary. Coming to today's topic, really, after Shardul finishes, there's very little to say, because he's really covered almost everything that we had thought we would say. But as a court practitioner in the NCLT, NCLAT and the courts, let me give my perspective from the litigation side of the IBC. As the Supreme Court said, this is a paradigm shift in the law. And a paradigm shift in the law requires a paradigm shift in the manner in which courts appreciate and approach cases also. And we saw from 2016, and because I had filed the innovative petition in the first place in the High Court here, that it took some time to get adjusted to the changed law. A law with 14 days fixed time to admit petition. Supreme Court, I think Justice Sikri told us that 14 days is not mandatory, it's directory, which is right, because you can't really tell a court what to do. You can fix a guideline, but you can't really restrict it in that sense. So the paradigm shift is 14 days for this, 180 days for complete resolution, another 90 days. If you don't finish in 270 days, then it has to go compulsorily into liquidation under Section 33. But lawyers and judges who have been lawyers always find a way. And the way we found was, I didn't do it, but the way lawyers found was, that though the Act provides for one extension of time, nowhere is there a bar in the law on exclusion of time. So this whole concept of exclusion of time was read into the Act by different tribunals at different stages, accepted by the NCLAT. And therefore the object of having a 270-day period, though it remained on the statute book, by and by it got eroded. Initially you excluded time where there was a stay granted by a court, so you couldn't proceed, which was correct and logical and which will probably still continue to apply, notwithstanding 330 days. But gradually different reasons were given. A reason was given that if a copy of the court's order under Section 7 admitting a petition was not received by the RP, and by the time the RP received it 15 days have gone, then that 15 days have to be excluded for the commencement of the insolvency period. For different reasons, and then court started saying that the RP couldn't do a certain thing for a particular reason. And by, this whole 270-day period lost its mandate. It remained in the statute book, it remains there, but courts really ignored it. So much so that, as Mr. Shroff said rightly, that it was necessary then to bring an amendment in Section 7 to remind the adjudicating authority, which is the authority under this Act to whom the NCLAT has been borrowed, that 14 days is there with an object and a purpose. And if you don't do it in this 14 days, then you have to give a reason as to why you're going beyond those 14 days. Of course, I must tell him, and I'm sure he knows as a practicing, well-versed lawyer, that the problem initially was number of courts available, because in 2016 when the law came, there was hardly any filing. In 17, as people read about it, it increased. And the flood has been there from 2018 and 2019. There's been an absolute flood of cases, particularly in places like Bombay, Delhi. There's a huge volume of filing. So this ability of the court to address a new filing in 14 days was constrained by the sheer number of cases being filed. Secondly, the threshold being so low, a large number of operational creditors who had lost the window that they had under the Companies Act were driven to the NCLT to make claims of 1 lakh rupees, 2 lakh rupees, 3 lakh rupees for goods sold, supplied and delivered. And even those cases had to be heard, listed and either considered for admission. The parameters for considering of cases by operational creditors or under Section 9 being different from where 7, the financial creditors claim, can be considered. Obviously, time got taken in those cases, and the whole cascading effect was that hardly any 31 applications for consideration of a final resolution plan, whether it should be approved or not, were heard, because the entire time started getting taken up in deciding Section 7 applications. So, the one thing I've seen is that the government has been very proactive, the standing committee even more so. A paradigm shift in the law, a new law, a law which is a work in progress, has been worked upon with great vitality and vigor and with immediate consequences, so that you've had multiple amendments to bring it in line with the requirements of the times. And that's one good thing which the standing committee has done, and they've addressed a large number of issues. The problem of time, which you then put a cap again in Section 12, according to me, what the standing committee, I'm sure they are aware, but they may also consider is that there are many cases where a resolution plan is already under consideration. There are reasons why, because of the back and forth between the COC and the court, the matter gets delayed. And if you reached a critical point, then I think this 270-day cap for cases, once they've crossed the threshold, namely, once you've reached a 31 stage and a 31 is under consideration, then again to bring back and say now everything must be over in 330 days is really difficult, because you may lose a chance because the whole idea is to have this resolution. Idea is not to go into liquidation, because in liquidation we all know what happens, that you really lose the asset, you don't get another person who take it up, even if you can sell it as a going concern. So a kind of cutoff may be placed that if cases have reached or attained critical mass by a resolution plan being under consideration, then at that stage maybe some relaxation in the law can be considered. This is on the timeline. Otherwise, it's all right. The second point which has exercised many of us is the treatment which is given to secured creditors by reason of the SR judgment. Fortunately, as we all know, that from the beginning, whatever the rights of a creditor are, under the different laws, under different statutes, those rights are not taken away. This is only a mechanism by which you bring it about to see that there should be an insolvency resolution. But merely because a secured financial creditor has come to the NCLT, made a claim, doesn't mean that his rights as a secured creditor cannot be recognized. There is a clear difference. Behold the insolvency law. There's always been a difference between different kinds of creditors having different kinds of rights. And there is a kind of hierarchy of secured creditors who have lent money to the borrower, on whose money is obtained again from the public, who are depositors with the banks and financial institutions, and who have lent money, and a person who has sold goods worth, say, 1 lakh or 2 lakhs of rupees. And to equate them, which is what the judgment in Enclad did, in SR's case, was a kind of shock, I would say, to all these bankers, lenders, because if this were to be so, that is under the insolvency law, you lose your right as a secured creditor, then why go to the bankruptcy court at all? Then you stand outside the bankruptcy court, go under SURFACE and enforce your rights and have your whole cake and eat it too. Now to ask them that because you've come to this tribunal under this act, to give up your claims, to shave off a part of their rights, is something which was wrong. And very rightly it has been addressed by the August 2019 amendment of the Insolvency Code. Of course, one can't speak much on it because it is already sub judice and being considered as we speak in the Supreme Court, both the correctness of the SR judgment as well as, I believe, the validity of the 2019 Act. But in my view, it was a correct view. And the reliance there on a passing reference in the Swiss Ribbons case, saying that there should be fair and equitable treatment, did not mean that you could take away rights of one to be fair and equitable to somebody else. Within his rights, you have to be fair and equitable to a person who's an unsecured creditor, not that you take away a security of somebody else in order to be equitable or fair to the other creditors. The next thing I'd like to address is the amendment in section 31, by which the central government and state government claims were also expressly made part of a final resolution under section 31. Now we all know that section 31, as it read, said that the final resolution plan as approved by the adjudicating authority will be binding on all stakeholders, including creditors, etc., 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 and it binds absolutely everybody. Therefore, the meaning of that simple phrase, that was well worded, simply put, section, was that all prior rights that you had as a creditor against this person stand extinguished, and now they will arise, whatever the rights are from now on. If you had a claim, whether you're government, whether you're a tax department, all that will get subsumed in the plan. If the plan doesn't make a provision for it, that's it, your rights and claims are extinguished. Unfortunately, and this is still continuing even after the amendment of section 31, this is the practitioner's perspective which Shardul, being in the committee, can take note of. That unfortunately, even after this, in case after case, and including one of the benches of our Bombay High Court, don't seem to realize that there is an extinguishment of all prior claims and rights on a resolution plan being accepted. And a suit, even if it had been filed earlier, the right under that suit will come to an end because the new person who takes the company and takes it under a resolution plan and pays good money for taking it is not going to accept any and every liability which may come at him from an unexpected blind spot. So the whole idea is that this will defeat a resolution plan. It will impede people from coming to and taking over companies if you hold that someone can just blindside you with a claim of 5 years ago saying I have a suit pending in so-and-so district court where my claim is so-and-so, I didn't make a claim under section 21, and a court or a high court holds that yes, that claim survives and you will still have to pay. The new resolution applicant who has taken over the company is still required to pay. So this really, the amendment takes care of it, but this is something which will probably need to be resolved through the judicial domain. On the same topic, there is one more issue, and that issue is of forum. The NCLT tells us, at least in some places, of course in some places they don't say it, and the NCLAT of course does what it does. But the NCLT tells us that once a plan has been passed, we are functus officio. So if somebody comes, as I said, with a claim subsequently against the resolution applicant who has taken over the company under section 31, the new person has to go to he has to go to the writ court. The writ court tells him that you go to NCLT, and the NCLT says we are functus officio. So the second problem is that the writ court may also say that if it's a tax demand, have you filed an appeal, because there is an alternate remedy by way of appeal under the Income Tax Act or under the Customs Act. And all these are issues which, as lawyers, it's okay. But a resolution applicant who's paid serious money to take over a company and who's grappling with bringing it back and putting it on an even keel and eventually making it profitable, he's not amused by these kind of claims coming from any and every corner. So either we have a provision, and this is also for Shardul to consider, whether we can have a specific provision. And I think it would be really in the fitness of things that, of course, NCLT has a lot of work, but still in the fitness of things for NCLT to deal with these things only. So you have a clear-cut forum, a forum which is familiar with the law, a forum which knows and understands by reason of having handled hundreds of cases, all nuances of the insolvency and bankruptcy code, which decides even if somebody comes against a resolution applicant, the resolution applicant must have a remedy of going to the NCLT from where he got the 31 plan approved and telling them, look, you passed my plan, you extinguished all claims, please now stay this proceeding and dismiss it. Today, all persons have to, people go, the resolution applicant may either go to the writ court or he has to go to the customs officer, you tell him you go in appeal. And there are multitude of forums and different people don't, they say, no, we have crown debt. How can you say that it is extinguished? We don't recognize IBC. So it's a suggestion that you may consider whether you should come and make a provision for it in the IBC itself. The judgment of the Supreme Court, and in fact the Companies Act provides, and this is again on the issues of litigants really, that the NCLAT should have benches in different cities. In Swiss limits, the Supreme Court gave the government 6 months' time to set up these benches, and which judgment came in February, so that 6 months must have ended sometime in July. But we don't see any movement on that, and I don't know whether we should move a contempt in the Supreme Court saying that the government has not implemented this provision, which is really necessary because every time you go, and there's again a huge backlog in the NCLAT where only one bench is hearing IBC cases to the exclusion of the other benches. Maybe it's changed recently. Till very recently that was the position. So that's one more thing which we need to do, is to implement the Supreme Court judgment in Swiss limits and see that there are benches everywhere. On consolidation of cases, there is a need for amendment in the Act. Because when we move for consolidation, as a case like Videocon, or there are now many companies where the structure is that there is a group holding company which is a listed company, and there are about 20 subsidiaries which are not listed and which are 100% wholly owned subsidiaries. And in each one of those there is a RP appointed. There's an insolvency of 20 companies. 20 RPs are appointed. But if you see like a company which is, say, just to give an example, making cars, in each of the subsidiaries, different parts of the car are being manufactured. And therefore, when you want to have an insolvency resolution, you can't sell the parts separately. You need to sell the whole thing. All 20 companies sell it as a package. And therefore, it is essential to have consolidation. But there is no provision in the Act for consolidation. Ad hoc solutions are devised by lawyers, accepted by courts. But it would be much better if there's a structure in place so that there can be no challenge to it. Issues of conflict between different RPs, issues of conflict between how the money which is eventually recovered is to be distributed between these 20 companies. All these issues will arise, and they will arise in the existing cases where the consolidation has happened already. There also, as and when the resolution happens, how will you distribute the money between the different companies? In the same light, there is another issue where companies have subsidiaries outside India. So, a large chunk of good assets are held outside India through foreign subsidiaries who are not subject to the rigor of the IBC. So, some issues, and therefore some creditor may just go there and enforce his rights. The benefit of those assets are not available to the overall creditors of this company. So maybe the standing committee and government can look at these. So this kind of reform, so as to make this law more effective. The law as it stands is good. It is, as we said, a process by which all of us are learning as to where we need to change, and the committee has been doing its job in an excellent manner. And I, for one, as a practitioner, I was very skeptical and cynical when we started in 2016 as to this new law which came, is the Insolvency Code. But my experience is that as we've gone along, the law has got kind of sorted out through multiple amendments. And practitioners and even resolution applicants, lenders, COCs, all have appreciated that this is a solution which was long awaited and has finally come. Thank you.
Gentlemen, now on that note, it's time for our next keynote address by none other than Justice A.K. Sikri, former Judge, Supreme Court of India. Let's have a huge round of applause to welcome our next esteemed speaker.
Thank you. Good morning to all of you and my panelists on the dais. This Insolvency Summit, the theme of which is the recent amendments and future trends. My previous speakers have virtually covered the entire canvas. Mr. Shardul narrated each and every amendment which has taken place in 2019 and what are the issues which have arisen in last 3 years and which are likely to arise because of that, which is beautifully supplemented by Mr. Ravi Kadam as well. And in the beginning, Mr. Vishwanathan had told you the historical background in which the IBC itself was conceived and how it came into being and how it is still a work in progress as the committee, which, as we are told, holds its meetings every 15 days, is looking after it. And I was just thinking and was telling Mr. Shardul also, just see the difference, the way the amendments have taken place so swiftly. It's the legislature, at least in India, we have never seen working with such elasticity, etc. Because see the example of Companies Act itself in this very field. What was conceived was in 1997 that amendment should come into as far as the Companies Act of 1956 is concerned, and took almost 16 to 17 years when we saw the Companies Act 2013 being passed by the Parliament. And I remember in those days, whenever I would attend international conference, even in this insolvency itself, this is Insol International, their conferences, I would be confronted with this question by the judges also, by the lawyers also, when the act will pass in India. We see every time various committees are set up from time to time, because many committees were set up which are given there, and white paper is circulated, comments are called, but act is not passed when the parliament would act. And so as compared to 17 years in bringing the legislation and within 14 days undoing judgment of the NCLT in SR case and acting so swiftly, which was the demand of the day. And this shows the paradigm shift in the as far as the psyche of the legislature also is concerned, and that is what is required. Actually, this, if I may say so, because I would not like to repeat whatever is said already, although I have prepared on that basis also, but I knew that much of that would be said going by the panelists who were in this inaugural session. And there are two reasons for that. It's already said, need not be repeated, and other is that it's already almost 11:15. And I think the session was to end at 11 o'clock. But then some of the aspects which I still feel need to be highlighted, I would be taking very few minutes to say that. Insofar as functioning of the IBC in last 3 years is concerned, or 3 years or so, some of the positive aspects which we see are that the winding up period, it's almost reduced from earlier regime from 4 years to 1 year now. Liquidation process is accelerated in the process, and the Supreme Court as well as the tribunal also has given quite a landmark judgments, except some of the judgments which were tricky and which were to be resolved through the legislative process has already been pointed out. But yes, overall, if you see, there are many judgments in many areas which have been given and which can be treated as a landmark judgment, and it is leading to jurisprudence developing at a very fast pace, because various new issues, various challenges are coming almost every day before the NCLT and NCLT, as well as the Supreme Court. As per the statistics given by the Reserve Bank, till December 2018, IBC had resolved cases involving rupees 3 lakh crores, and out of which rupees 1.2 lakh was at pre-admission stage itself. Rupees 60,000 crores NPAs were turned into standard accounts, and what the RBI concluded was that the recovery rate under IBC has been 42% as against 10 to 15% in the earlier regimes, SICA and DRT, etc. So that may be on the one side of it, but at the same time, let us see what is the scenario, what is the landscape, or what are the circumstances under which this law is today being governed. And we have to keep in mind that, and in the light of the amendments, what is the way forward and what are the challenges we are going to face in future. I would deal with that. First is that we are in the era of a slowdown of economy. It's a it's not okay, one can say, and take some solace in the fact that it's not a phenomenon which is only in India, it's worldwide. See, Chinese economy is in worse position than even in India and in many other countries. But at the same time, the attempts are being made and we have to come out of this slowdown. But this has repercussion and direct impact insofar as insolvency issues are concerned. Because in such a period, the companies which go bust and the companies which become insolvent and the NPAs accounts, etc., is increasing, and it is happening, and this figure is swelling day by day. That is one part. And other is that when many banks and financial institutions are filing the cases before the IBC, and it is becoming almost, I have given the figure of that 3 lakh crores, etc., the NPAs resolved, but the flip side of this is that many times the fear which is there is that IBC may not become a tool for recovery only. that financial institutions who have to go there and they have to file the case and they have to recover, and as if the only way is to liquidate the company or to transfer the assets to some other buyer, some other management companies. We have to keep in mind the fact, and that is what on this I will take some time at a later stage, that what has to be the approach of IBC and how the balancing is to be done in two competing fields. Because if the companies, we start liquidating the companies, only the slowdown which is happening would trigger further. So that is the catch. That is the, and therefore the job of the IBC becomes very, very delicate in such a situation. And let us be frank that in spite of this law being passed and where the Indian ranking had risen and it come to 79 and now it is further, I think, 60 or so, we have been credited for that at international level, but still many investors are still waiting on the sideline to measure the outcome of the settlement of big cases and evolution of IBC before investing. That is still, I mean, it's not that to that extent the positive effect insofar as the big investments are concerned. And that may be also because of the reason, as is told to you by the previous speakers, that delays are still taking place even under the IBC, notwithstanding all these amendments and what would be the repercussions of these amendments, where the period is to be excluded and not excluded, and how in future still the, I would say here, as Shardul said, and I use the expression, if I am allowed to do so, that it may be ingenuity of the judges to come out of it and still say that the delays, such and such periods are to be excluded. But there may be various reasons, apart from some, I mean, situations which may be out of the control, like where the stay is granted, you can't help it. But then there are procedural inefficiencies, and there is a lack of infrastructure as well, which has to be, I mean, looked into by the government. There is, I'm very frank in saying one thing more, and which I keep hearing because I don't have my first-hand experience. I have not appeared before this NCLT, etc. But lack of skilled and specialized judges. There may be few very good judges, but then we can't say that. And this is in a when we have to work a code like insolvency and bankruptcy code, which is a specialized field, we have to have specialized judges who are trained and skilled in this very branch. And there are not too many, and many still go by the orthodox approach which is in the judicial system in normal cases, and maybe SR case was one of the examples of that, I would say. But then this is another, and spate of cases being filed in last 1 year, 2 years, which Mr. Ravi Kadam also said, because of which NCLT is becoming overburdened. So how to deal with the timelines when you are overburdened. And in the process, very interesting thing which was said about one of the issues which is raised is the other agencies or other laws coming in between. Of course, the Supreme Court have said in one of the judgments that look, that was the case Maharashtra, that Act and this IBC of Innovative. Yes, that exactly. Thank you. And the judgment, of course, based on Article 254, that repugnancy and the Central Act would prevail. And now the amendment is also passed, and therefore the debts which is not there, which is not the part of the scheme, they cannot come. And which is going to be the, as well as the government dues, etc. concerned, like you are told, ED has given notice. Of course, in spite of the law being settled on this, I read yesterday only that NCLT has to decide whether the ED's notice of attachment, where the process of restructuring is going on, whether that would have priority or not. I tell you, only 3 days ago I have dictated one opinion which came to me, and it's another very, very interesting situation. Here there was a this power generating company which had which was given the license to run, or this arrangement with the one of the state power corporation. And you know, under the Electricity Act, the tariff is to be fixed by the regulatory authority, state regulatory authority. So in that particular case, it was done, the tariff was fixed, and rather it was the arrangement which was there, which was given imprimatur by the regulatory authority, that particular rate at which the company, after generating the power, had to sell to the this electricity commission in the state, and how much they could sell of their own. And that tariff was fixed, but for some reason this company became insolvent, and the account became NPA, and most of the debt was due to State Bank. The bankers consortium was there, and it was about 10-12,000 crores. And the matter went to IBC, etc. Ultimately, the CRP, they could come out with the resolution, and two foreign companies in collaboration, I'm not intentionally naming all these parties, because case may go up to the Supreme Court, we don't know. At that stage, they have come to opinion before it would. But let me tell you, they ultimately, the shares were pledged with the State Bank of that company which had taken the loan. So when the account became NPA, the shares, that scheme was, arrangement was made, and the shares were sold. And this consortium, or the joint venture of a French and Italian company, they bought that. And it was, the entire deal was about 6,500 crores or so. And out of that 10,000, 11,000, which is said, most of this was interest element, etc. But the SBI thought that this is the fair price of these shares which they are getting, and their principal was even less than 6,500 crores. Now, with this, when this arrangement was made, they went to the that company which had given the license, that is the State Commission, this Electricity Commission. Then they said that no, you approach the regulatory authority. Now, regulatory authority, first of all, I feel that it had no function to give its approval to such an arrangement, but they went on a tangent altogether different thing. And they said that, look, the debt was so and so, 10,000 or 11,000 crore, 6,500 crore, so you have benefited by 3,000 to 4,000 crore, and therefore the tariff at which rate you had to sell to the commission, we are reducing it. Now that is the order which was passed. Against this, the State Bank of India, which is supporting the joint venture, and the joint venture, they went to the APTEL, the Electricity Appellate Authority, which has reversed the decision. I said that it could not be, it was without jurisdiction. Of course, these aspects and how IBC regime, etc., have not gone into, which I have stated in my opinion. But then they have come at this stage and they were asking, look, what are the chances if they go to Supreme Court, and some other aspects, which I need not say in detail. But then these kinds of issues may also arise. And it was very interesting and different kind of issues, and how some of our authorities can behave in a different manner without even having any knowledge about this law and how this law has to be applied. So these are some of the issues. I tell you that I wanted to say the challenges because of these which we are facing and which the NCLT may face is, one is about the group insolvency, about which it is said. Other is about which is a related subject, about the cross-border insolvencies, on which much is said, and there are going to be 2 sessions in which me and Shardul are also there, so we'll be speaking more about it. But there are, I would say, challenges of restructuring also, the way IBC has, the NCLT has to act upon this. And I find that 2 or 3 years ago, a very good work was done by Singapore in this field, and the Singapore committee had given some suggestions. Because normally in this restructuring, what happens is that tendency of the debtor is to postpone the problem by, because they do not want to lose the control. On the other hand, whenever such a package is to be, what is important is that there is a necessity to understand the business, to understand the problem. So what kind of business it is, what kind of problem it is, and because it should take care of the need to preserve the assets or the value of the assets, which is more important during restructuring process. So therefore, process of liquidation is not to be taken lightly in the process. And another important aspect is that in such matters, we have legal aspects and we have commercial aspects. They have to be clearly demarcated, and as far as legal aspect is concerned, that's a role of NCLT, but the commercial space is to be given to the resolution professionals, etc., which again is very, very necessary. And as it is said, which I wanted to say, and that is Singapore example also, that the binding framework, when the framework is arrived at, it is binding and everybody has to respect that. I was, even the day before only, I saw in one of the newspapers, I think MD of the State Bank of India saying so that, look, once the company is handed over to the person, investor who has come in, they should get it free of any charge, and there should not be any problem with this. Otherwise, it would be, act in a negative manner in future. People would not like to come forward. This raises the issue, which I would say here, and that is the approach. As a judge, I am saying so, as far as NCLT or NCLAT, etc. is concerned, that this is one law which is closely connected with the aspects of economics. So this close connectivity of law and economics has to be seen by every judge, every member, every bench who decides such cases. Because, and here, what is material, without stating in detail, I had the occasion to say so in that Shiv Shakti judgment in the Supreme Court, and where I said that why it is today necessary for the judges also to take it to account the economics of judgment, in the sense what are going to be the repercussions, not only the economic factors which are there between the parties, but even because this is one law which has the effect on the development of the economy and the nation itself. So this is very, very important. What should be done in detail, is a matter for some other time to say, but I'm highlighting this aspect that this economic approach to law is very, very essential by the judges, and they have to be trained. In one or two this judicial colloquia of the NCLT judges, I have told them when I was invited and how we have to do it. That is very important. And the other thing which I want to say is, and that is important because it is not touched by anybody, and I'm happy at least I'm able to say one thing of my own, is that mediation in the insolvency process, which is very necessary. It would not only take care of the overburdened NCLT which is happening at present, but then it will also be a process. Normally, we have when the resolution professional is appointed and he takes into consideration, he will convene the meetings of the creditors, the shareholders and others. But here, all the stakeholders can come together and can devise a mechanism which is acceptable to all, and on the basis of this meeting. So mediation, again, is a very important thing. I have co-authored one article which was published in Business World a few months ago. It was on mediation in corporate insolvency only. Because of want of time, it is not possible for me to say in detail about it, but according to me, it can be a game changer, and it can take care of so many aspects, and it can be it can lead to a situation which we call a win-win situation. Thank you very much.